Is PalWorld legal? In today's video, I'm going to be reacting to RDC's video titled How Pokemon Talking to Their Lawyers Right Now About PalWorld. Now, in case you've been living under a rock, PalWorld has been taking the internet by storm. And a lot of people have been saying, hey, isn't this blatant intellectual property theft? How can this game exist? Well, I'm gonna provide some legal analysis. And of course, remember to spam me where I'm attempting to make a video every single day. And Pirate Tom is back. I'm wearing my eye patch at the office because y'all were making fun of me for my lazy eye. Let's get started.
Attorney Tom.
Okay, so help me understand. How do I not have a case? That's literally a black Lucario.
That's not a black Lucario. That's Anubis.
Anubis?
In PalWorld, they call him Anubis, yes.
What? They stand in the exact same though.
Okay, just because you change the name of something doesn't necessarily protect you from copyright infringement. There is a much more expansive analysis that you need to do. And this is a great time to bring up a famous intellectual property case involving video games. Behind me is the Wikipedia page for Tetris Holdings versus Zeo Interactive Inc. Let me give you a primer on the case. Essentially, Zeo Interactive created a Tetris clone. Here is the Zeo Interactive game on the right, and on the left is Tetris. So Tetris sued for copyright infringement. Now, a couple of very interesting principles became clear from this case. First and foremost is you can't have a monopoly over a genre, over a type of game. The merger doctrine, where some ideas may only have a limited number of ways of being expressed, and it would be legally unfair to protect expression if it effectively gives someone a monopoly on an idea. For this reason, the Copyright Office advises that the copyright does not protect the idea for a game, its name or title, or method or methods for playing it, nor does copyright protect any idea, system, method, device, or trademark material involving in developing, merchandising, or playing a game. Once a game has been made public, nothing in copyright law prevents others from developing another game based on similar principles. In other words, there's only so many ways that you can play Tetris. The puzzle with the different shapes, and then if a line gets completed, the entire line vanishes. You can't own that idea, okay? But you can own the totality of the expression of your game. So while Pokemon can't own the idea of a world where you have a monster and you control that monster to go fight other monsters, that's not something they can protect. But again, you can protect the totality of the expression. And in the Zeo Interactive case, actually they were found to be in breach of Tetris's copyright. And it wasn't because of the gameplay, which we've already established they can't get the copyright for the idea, but it was because the games look substantially similar. And this case led to the famous squint test. The judge explained that the court should compare the games as they would appear to a layman by concentrating upon the gross features rather than an examination of the minutia, essentially comparing the game's respective look and feel. Wolfson further wrote, if one has to squint to find distinctions only at a granular level, then the works are likely to be substantially similar. I don't take sponsors. The only thing I ask is that if you need a lawyer, contact my team for a free consultation. While most people know me as a catastrophic personal injury lawyer, I'm actually a partner at 2 law firms that handle way more than just catastrophic injury. If you were the victim of securities fraud, received a notification that your info was included in a data breach, developed cancer as a result of a bad drug or toxic exposure, and many other situations, we may be able to help. It's important you talk to a lawyer right away to understand your options. If your case is not the best fit with us, we can help you find a great lawyer by using our national network of attorneys. Please click the link down below for a free consultation. Now, just having characters look the same is not all-inclusive. Remember, you have to look at everything, especially when you're not looking at the prime characters. I think it would be a different analysis if they had a replication of a Pikachu or a Charizard or a Squirtle, you know, the main Pokemon, right? Those are what I think of when I identify Pokemon. But if you have these kind of secondary Pokemon that maybe aren't individually trademarked, like I can guarantee you Pikachu and Charizard are, then you have to look at the totality of everything. So yes, they look similar-ish here, but I mean, how many other characters in the world of animation also look like this? Additionally, when you look at the totality of the gameplay, a big thing about this is people are calling it Pokemon with guns. I don't think you have to really squint to find out that there's a difference right now. But let's keep examining.
They can't stand it. Come on, his legs is closer. They can
What?
stand
A little closer? Are you
You
for
don't
real?
have a case. Listen, you're the Pokemon CEO. We understand. You don't have a case right now. I'm trying to help you out.
I understand. Okay,
You're my client.
maybe you're right.
Like, you don't have a case with.
Okay, yeah, absolutely. As a lawyer, you have an ethical obligation. If you feel like the client would be wasting their money in a lawsuit, then you have an ethical obligation to say, hey, listen, you're probably going to lose. Why waste money on this? Now, in reality, when you're dealing with mega corporations, sometimes they will sue anyway, even though they know that there's a very small chance of prevailing, because they want to send a message to the rest of the world saying, you better not even come close to our IP or we will make your life hell. We might lose money, but you're going to spend a lot of money defending it.
Is that not easy?
Somebody texted me. Hold on.
Man, who is texting, man? I'm paying for this song.
Oh, no, it's my other client.
He says that's my other client. He's texting PalWorld. Look, you can see it. He says PalWorld. He goes, bro, you tripping. Y'all know you could have changed Eevee a little. Okay, so I take back what I said about this lawyer being ethical. He's now trying to speedrun getting disbarred. There's a clear conflict of interest here, especially when he just blatantly admits that PalWorld is his client, although Pokemon doesn't know that the client is PalWorld. This is bad. This is bad for a lot of reasons. This is illegal. This is, no, don't do this.
Can he not wait?
Yeah.
Is that not Eevee?
That's Crimus.
Crimus. How much time have you spent on this game?
I had to do what I had to do.
How much time? You know every Pokemon
Listen,
name.
I had to do what I had to do.
How
make
much
sure
time did you spend on
that
this game?
I had a case for you. I was looking. I was playing the game to see how much.
How much time did you spend?
40, man.
What?
40.
40 hours.
So 40 hours, you're probably paying a lawyer between $700 and $1,000 an hour. You know, that's getting paid 30 plus grand to play PalWorld. And getting PalWorld as a client, this is the real guy making money.
Yeah.
Time be going by fast when you playing it.
I see what's going on.
What's going on?
You protecting him.
I'm your lawyer.
You're a fan of this game.
I'm not, man. PalWorld, you pay me. I play Pokemon Yellow, Blue, Red.
Get up.
I was trying to build a case for you. So I got on PalWorld thinking about Pokemon. I had to get detail after detail.
So, you know what? Other than him being working for PalWorld, that is, you do, as a lawyer, somebody's got to play the game to figure out all the infringements, right? There is someone in the world who is getting paid right now to play PalWorld for Pokemon. I can almost guarantee that.
And I put the gameplays of PalWorld and Pokemon next to each other and realized it was perpendicular.
Man, this bullshit, bro. Get out of my house. Ooh.
That was great. So next I pulled up a clip from Twitter where they were comparing Pokemon and Pals. Let's see if let's apply the squint test, everybody. Okay, all right. Like and subscribe. Here's my analysis. I think a lot of the art in the Pals and Pokemon might not pass the squint test. However, the gameplay as a whole, the guns, the grenades, those are clearly very in favor of PalWorld. ultimately it depends, right? I think probably Pokemon would sue, and it's just gonna come down to the judge, to the jury, to the lawyers, and you know, there's obviously no clear answer because some people might say it infringes, some people don't. That's the beauty of the law. It depends. All right, y'all, talk to you later. Bye.